Assalamu alaikum. Today we will discuss checklist of various factors that will be considered while adopting any method of alternate dispute resolution. The following checklist of factors may be relevant in diagnosis stage of any classification system to determine which case may be appropriate. First is whether the matter is complex or likely to be lengthy. Second is whether the matter involves more than one plaintiff or defendant. Third is whether there are any cross claims. Fourth is whether the parties have a continuing relationship. Fifth is whether either party can be characterized as a frequent litigator or there is evidence that the subject matter is related to a large number of other matters. Sixth is whether the possible outcome of the matter may be flexible. Seventh is whether the parties have a desire to keep the matter private or confidential. Eighth is whether any party is a litigant in person. Ninth is whether it is appropriate time to refer a matter. Tenth is whether either or both the parties express a desire to mediate, conciliate, or negotiate. 11th is whether the dispute has a number of facets which may be litigated separately at some time. Depending on the answers to the above questions, the method of resolution has to be adopted. The disputant should be conscious of the goal to follow the appropriate means, thus creating sufficient awareness about the various alternatives in essential. ADR is not isolated from law and justice, it is just an other means to achieve it. In ADR, the court decides the type of process to be adopted. In other words, the parties have to first recognize their requirements and then choose the appropriate alternate dispute resolution method. For instance, if the parties want finality of decision that are binding on the parties, then they should go for arbitration. If the parties want to protect their relationship, then they should go for mediation. If the parties want to tackle the power imbalance, then they should go for negotiation. If the party want to face cultural differences, then they should go for direct negotiation. And if the parties want the backing of law, then there is conciliation.